We're going to go ahead and call to order our work session for, work or training? It is a work session. It's the training's on the front end of the work session. Our work session for Wednesday, October 15th, 2014. Mr. Thomas, I believe you're presenting training for us? Yes, please.
Regarding sovereign immunity, both as it relates to the city of Brookhaven in general, but as well as it relates to elected and appointed officials, and specifically in connection with your role as board members of the Zoning Board of Appeals. Before I get directly into that, because they're interrelated, and you may have already heard this before, but I would kind of like to go through the type of legal actions that you would see and the process involved there, because being a Zoning Board of Appeals, it's different than it would be if it were the City Council, because you're making administrative, quasi-judicial decisions as opposed to the City Council, who's making legislative zoning decisions. And so those matters are handled differently. The administrative zoning decisions that a Zoning Board of Appeals makes primarily, although there are other things that you do, would be those decisions regarding variances and regarding appeals from a determination that would be made by a city official or city staff such as Ben or others making a determination of what the application of a provision of the zoning ordinance. What you're required to do under those circumstances is when an appeal is made or when it's seeking a variance, you just what the law says that you are obliged to do with respect to the applicant is provide reasonable due process for them to come forward and be heard. And the zoning procedures law, which applies to your actions and which the staff, of course, is very familiar with, they will follow that so that you do meet those minimum due process requirements. Just by virtue of doing that. So that's the first thing you have to do. Then secondly, you do not have to, even though it's quasi-judicial, you do not have to adhere to the strict rules of evidence that you would normally see in a courtroom. It can be more informal. And oftentimes there may or may not be attorneys that are involved in the process for the applicant. Because your actions are quasi-judicial, you have standards that you're to follow that have been designated in an ordinance that's been adopted by the City Council. You know what those are for variances. You're to listen to the facts of the case and then apply the standards to those facts and make your decision. So you're sort of acting like a court. And because you're acting like a court in that respect, the appeals process from a legislative decision that's made by your city council as opposed to your administrative decision or quasi-judicial decision, the appeal process for and the standard of review at the end of the appeals process is different with respect to decisions made by the Board of Zoning Appeals versus the City Council in making their zoning decisions. It's technical, but basically when someone appeals from a decision that you've made, they go directly to the Superior Court. And they can go, there's three methods by which that takes place. It's either writ of certiorari or mandamus, I believe is the provision that you have, or there's also a direct appeal. But that's provided for in your ordinance. Here, I believe it's mandamus. It can get a little tricky when someone's appealing because the procedures that the applicant has to follow to appeal the decision is different under all three of those things. However, the review is the same. Again, because you're have acted in a quasi-judicial manner, the way the Superior Court reviews your case is like an appellate court would. It's totally on the record. There's no new testimony. No new evidence is allowed in. When you have your hearings, they're recorded, and everything that's considered at those hearings become part of the record. And that record is certified if there's an appeal, and it goes up to the Superior Court. Superior Court looks at it. Of course, the lawyers, brief it and that sort of thing. You may be named as defendants. I mean, the board is basically the defendant, but you could be named either in your official or individual capacities. You should be named only in your individual capacity. Sometimes lawyers like to name you they like to name you in individual capacity because they think it may have some effect on you, but typically there's no basis for an action individually. But the court looks at the record as a whole. There is no more evidence. You probably won't even be involved in the case. It's possible that your deposition could be taken, but generally in the cases that I've handled, and I've handled about a number of cases, 20 or so, cases against various zoning boards of appeal. I've been able to quash depositions because under the scenario or basis that they're getting additional or new information and they should only be looking at the record. So oftentimes you're not really even involved in the litigation. We would try to keep you informed of where the stage of the case and what was going on. We would copy you when we file our motions and our briefs. Typically, the court is going to decide the appeal just on a motion. The lawyers will present their briefs and their arguments, and then the court will make a decision. And the standard of review is very much favors the zoning board. That is, if there is, quote, any evidence, which is a different standard than normal. It's not a presumption, or it's not 51%. It's if there's any evidence, then it is the duty of the Superior Court judge not to substitute his or her judgment for yours. It's the duty of that judge to defer to your determination if there's any evidence. And the reason I go through that for you is to give you some degree of comfort that with respect to actions against zoning board of appeals, most of the time you're going to prevail on those. As long as you have followed your, with respect to your process of adhering to the criteria for variances that are set forth. And you'll see more appeals from denial of variances than you will see from someone challenging a decision you make where you're making a determination as to whether or not the decision made by the zoning director was correct or not. I would say that 80% of appeals from zoning board of appeals cases are based upon your denial of a variance. Also, 95% of those appeals are by the applicant because a third party, like neighbors in the community, really the legal standard there is that they, for the most part, do not have any standing to challenge your determination. So again, you're just looking at potentially actions that would be filed by the applicant for the variance who's not happy with your determination. So then that leads us into the question of, or the issue of sovereign immunity. And official immunity, which is really more applicable to individual board members. Generally, we'll start with just an overview. The whole concept of sovereign immunity is that, it's government, or the king can do no wrong. It's common law, back from Great Britain. The more modern justification for it is that sovereign immunity is to preserve the public purse, because you're really looking at taxpayer dollars there. And sovereign immunity is, in Georgia, it's based on a constitutional provision. It's Article 1, Section 2, Paragraph 9 of the Constitution. It provides that sovereign immunity extends to the state and all of its departments and agencies. The sovereign immunity of the state and its departments and agencies can be waived by an act of the General Assembly, which specifically provides that sovereign immunity is thereby waived to the extent of such waiver. Here, you can waive sovereign immunity, the city can, by purchasing insurance, but the waiver only extends to the level of insurance. And that's and that comes up more, it's more common with respect to matters that involve torts. Like, for instance, City of Atlanta, as recent as 10 years ago, they did not purchase insurance, so they had sovereign immunity. But they did establish, which you can, your own liability scenario. And for instance, wrongful death, they provide that they would have a $500 payout for wrongful death. The state then changed that and provided by statute to waive that immunity and require the purchase of insurance up to a certain level for certain things, one of which, of course, would be motor vehicles. But here, again, sovereign immunity and the principles of it apply to you individually, but it's more official immunity that applies to personal liability of appointed and elected officials. And the rationale for that is that you preserve the appointed officials' independence of action without fear of lawsuits, and to prevent a review of your judgment in hindsight. So, I mean, that's, again, the deck is stacked in your favor on that. There's also a distinction where there can be an exception to official immunity or sovereign immunity, and it boils down to the distinction between ministerial acts and discretionary acts. I know that's a technical term, but basically, as far as discretionary acts, which require the exercise of personal deliberation and judgment, entailing examining facts, reaching conclusions, and acting on them, that is considered a discretionary act, and you are immune for those discretionary acts. A ministerial act is something that is where you're just carrying out a regular duty, an employee or an official, such as an inspector. Now, if an inspector is negligent in performing a ministerial function, which is an inspection, then the immunity, if there is negligence can be established, then the immunity does not apply. Again, the primary section is Article 1, Section 2, Paragraph 9 of the Constitution. All officers and employees may be subject to suit and may be liable for injuries and damages caused by negligent performance of or negligence, failure to perform their ministerial functions, and may be liable for injuries and damages if they act with actual malice or actual intent to cause injury in the performance of those functions, except as provided in this subparagraph. Officers and employees of a state or its department and agencies and boards shall not be subject to suit or liability, and no judgment shall be entered against them. There's an additional statute. Well, the statute for the municipal corporation is 3633-1. It generally restates the same provisions we've been through in terms of the ministerial and discretionary duties. There's an additional statute that applies for board members. It's considered supplemental. You have your constitutional immunity, but you also have your supplemental immunity that's provided under OCGA 51-120, which basically, and this is really most on point to members of the ZBA. But let me track back just for a second. Again, what's most important for the ZBA under the general constitutional provision of sovereign immunity and official immunity is the fact that you, almost by definition, are making discretionary decisions as opposed to ministerial. So you're almost always going to be immune. I can think of very few circumstances where you would have discretionary where you would have non-discretionary acts or ministerial duties. All right, then 51-120, which is specifically does apply also another layer of protection, provides that a person serving with or without compensation as a member, director, or trustee of a local government board shall be immune from civil liability for any act or any omission to act arising out of such services if such person was acting in good faith within the scope of his or her official actions and duties, and unless the damage or injury was caused by willful or wanton misconduct, and we'll get into that. We'll say, it says serving without compensation. That has been interpreted to mean that if you're being reimbursed for reasonable expenses, that's not compensation. If you're receiving a nominal stipend, that's not compensation. I don't know if your board receives a stipend or not, but so this would.
Or volunteer. We get dinner, yeah.
I understand.
And that's usually donated.
As long as you're working for nothing an hour, it doesn't matter how many hours you're working, and I understand you're working a lot, from what I hear. So again, that's supplemental, and the only, here we get into the question of willful or wrongful misconduct, and the statutes don't really describe that or define that in detail. There's case law that's developed under those, and the case law sort of hashes it out. But try to give you an example of what you might have to do to be found to have done something willful or wanton. It's not simply bad judgment or negligence. It would have to establish a dishonest purpose or some moral wrongdoing. It implies conscious doing of wrong and means breach of a known duty through some motive of interest or ill will. I mean, they would have to establish that maybe you have a personal hatred for some individual or something like that, and you wouldn't approve something for that person under any circumstances, and that you worked hard to try to convince your fellow board members or something like that. Again, an almost impossible standard to meet. And again, the preeminent case there is wanton and willful conduct differs from even gross negligence. Willful conduct is based on an actual intention to do harm and inflict injury. wanton conduct is that which is so reckless or so charged with indifference to the consequences as to justify the jury in finding a wantonness equivalent in spirit to actual intent. So again, you have very high degree of, a very high bar there for anyone to establish a cause of action against you. Now also, here, as with many local governments, the city of Brookhaven is also going to purchase insurance. And the insurance is basically if an action is brought against the city or the board and the board members, and typically it's brought in your capacities, it's your official capacity in the performance of your duties, and you're not named in your individual capacity. Although we are a pleading state and you can put anything you want to in pleadings and the court has to hash it out. But the city has coverage for liability that would cover you in your official performance of your duties. A lot of times you'll see broad counts in a lawsuit where they may say, well, you did act willfully and wantonly, but they don't have any facts to support that. But the insurance company is still going to provide a defense. If you're alleged to have done something in your individual capacity, they may, quote, provide the defense of that portion of it under a reservation of rights, depending on how the case were to come out. But they're going to provide the cost of defense, so you wouldn't have to provide, your own attorney. You're allowed to provide your own attorney, but you don't have to. Typically, there's never going to be a monetary judgment in a case that you're involved in. But if there were a monetary judgment, then you would be in most, not all, but in most, very, very much most circumstances, the policy will indemnify you. And most of those cases are going to be settled and never go to judgment in any event.
And is that only up to a certain dollar amount? I mean, what if?
Yeah, the city would have, and I don't know what I did pull up a copy of their policy I was looking at on the way over here. I'm not sure exactly what their limits are. Ben, do you know what the limits are? They have there's an umbrella coverage. In other words, you may have liability for generally of $1 million or $2 million, and then there's a $5 million umbrella over that. So it's going to be very substantial coverage. It'd be almost, and to the extent that a judgment would exceed, you've only waived your immunity to the extent of insurance anyway. So there could be no excess judgment against you because you'd be immune from that. So
Is the ZBA included as a named insured on that policy, or is it a city council?
it says elected and appointed officials, and you are appointed officials. So, and you fall within, and typically they do list the boards, but if you're an appointed official, which you are, you definitely meet the definitions of that. Let me see if I got it.
So if we were, say it's a $5 million umbrella policy, a commercial developer comes in, wants to do a large project, ends up filing suit, and the judge does find monetary of, say $6 million. The insurance policy would cover $5 million of that, and the rest would essentially fall by the wayside due to the immunity.
Right. And the likelihood of a monetary award, typically what's going to happen in a case is if you're determined to have, the court says, well, I don't see any evidence to support your decision. So here's my judgment. I reverse it.
Right.
So you get your variance.
So long
but you
as we're
don't get your
following the criteria and
exactly.
applying those.
They could bring what we call a 1983 action, which brings up constitutional issues under federal law, but where there's potentially damage there, but rare, extremely rare. I've got the policy covers money damages incurred arising out of an act of an elected or appointed official, including ZBA members, while acting within the scope of their duties. There are exclusions if the official is found to be gaining personal profit or advantage, or engages in fraud, dishonesty, or a criminal act, or, and that's essentially the only exclusions.
So Thomas, does it cover cost of defense?
Yes, it does.
That's the main purpose of it.
Yeah,
Defense costs.
it would the cost of defense would be, you would be indemnified for that, and then as well as any judgment, you'd be indemnified for that.
Is that defense, the only time this has become an issue since we've had a ZBA was when the city actually filed the writ of cert and named us all individually, and we didn't know it was coming. We were caught off guard. We were very, taken aback by it. And a lot of the questions I had at the time were, do I need to go and get a lawyer? Is that paid for by the city? I understand it would be. But if that were to happen again, and it actually went to court and we felt the need for an attorney, would we choose that attorney, or would the city choose that attorney? It would seem to me there would be a conflict there if the city's choosing the
Typically,
attorney.
I can answer that too I'm sorry, Sam, I didn't mean to interrupt you. My understanding right now is that I forgot his name, isn't that horrible? Mr. Smith would be the one representing you.
Okay.
Now, at the insurance company, we don't have control who the insurance company picks. They typically
Town
pick their
council.
own.
But now that
attorney.
we have chosen an attorney for the
Right.
ZBA.
The insurance, as far as who's going to pay the attorney, the insurance company is the one who's actually, they have the right to determine which law firm that they work with and they assign to defend the case, and that's who they're going to pay. Now, the insurance company is not going to pay an attorney that you may have, but it's my understanding that if in fact the city has chosen to allow you to have an attorney that represents the board, then the city would be responsible for paying the fees of that attorney.
If we were put in a position to defend ourselves against a city action, that insurance policy is not going to cover employee on employee suit. It's like, they're not going to defend the city and indemnify the city and indemnify us under the same policy.
Well, if you're named as a defendant, if the city's filing the writ of certiorari, but nonetheless, if you're named as a defendant, they will have to provide a defense for you under the policy.
The insurance company.
Yes.
If action is brought by
Yeah, that does
another
seem
named
like it should
insured.
be.
I don't see that.
It would be a separate counsel. You would have the right to demand separate and independent counsel from the insurance company. I have had that. It's been 10 or so years ago, but I had an instance like that occurred in another city that we were representing.
But regardless.
But I was surprised you were named in your individual capacity. I would assume you would be named in your
Sure.
We were
official
surprised
capacity.
We were too.
Okay.
But regardless, the city would not be choosing the attorney in that situation.
Not in that scenario, they should not be.
Either the insurance
Again,
company or the attorney already in place would be
Right.
representing
about
us.
that, but
Or depending on the carrier, it could be
I usually
panel
know what's
counsel.
coming.
You can choose from a panel of pre-approved attorneys.
Right, right. And typically, they would have another group of attorneys where there is a conflict. They're on a list, like you said, a panel, and where cases can be referred to, where there would be a conflict. So you should be covered in that instance. I can see why you would have legitimate concern about that. But you should be okay.
I'd rather you tell me I am okay than I should be.
You're okay. You're absolutely okay. How's that?
I like that a lot better.
Yeah, if
Sure
you've
it
got
is,
any
yeah.
questions, I mean, some of this is very technical, but I'd say the types of cases that you're going to see and the standard and the immunity and the type of review, all of those things are in your favor. Actually, I can't recall. I guess, in my experience, there's only been one case I defended that involved a Board of Appeals where we didn't prevail in the case, and that was because we ended up settling it in part of that process. And that's not because I'm a great litigator by any means. It's because generally, unless you're acting, just way out of bounds, the law gives me great deference in defending you. So you should feel comfortable with that.
So that being the case, why, and I don't know, Emily, maybe you could speak to this, but if we can use a real-life example, when the city did file the writ of cert against the board, was it the position of the city at that point that we were acting way out of bounds and
I would assume they were
Judge would
thinking that
not
you just
have-
made an error in judgment. But
Yeah, and it wasn't, I don't believe that it was out of bounds. I think that they agree I know which case you're talking about, and it was just that we didn't feel that you had properly applied the standards to the case, the standard of review, which I think is what most of, and I don't want to speak out of term since I am in front of you on these cases. I think that both sides, that's what they're going to be saying if they disagree with your decision.
Right, but it seems to me that if the judge is looking at, was there any, not a majority or 51% or what have you, but was there any
any
just
evidence?
cause there, any evidence to rule the way that we did?
On both sides, I've argued that there's been procedural mistakes. That might be a grounds for reversal, and that the standard of review wasn't applied correctly, and that could be the developer or the applicant or the city probably would be making that same, it's the same argument on both sides. And the city's probably not going to make a constitutional objection, but in all fairness, the applicant probably
Right.
would be throwing that in too.
Yeah, you'll see, when you see a lawsuit come in, it's usually going to be, multiple counts. And usually, most of those counts are dismissed, and they're just there a lot of them are there for show. I would think that the city would, in order for the city to appeal, they would have to feel strongly that it was a misapplication of the standard, and they wanted to defend that standard. Other times, you'll see them say, okay, well, maybe that was ambiguous, and maybe we need to change the statute to be more clear on that. A lot of times, you'll see that come out of it as well.
I just remembered that case that you're talking about in better detail. You'll have to forgive me, there's been a lot since then.
Yes.
That particular case was because we were concerned that we might waive our rights if we didn't do it, because there was some question about on both sides.
So when you're uncertain, you sue everybody? Is that?
Unfortunately,
Yes.
sometimes.
No hard feelings.
I would always tell my clients don't fear a lawsuit. And then I got sued one time. And I said, what in the world is this?
Mr.
It's bad
Beardsley,
when you see your name on a lawsuit.
Yes, absolutely.
that being said, I'm not admitting to any frivolous litigation or anything along those lines.
For the record.
For the record.
Miss Emily.
Any other questions? Or,
I think
Ben,
I'm
is there
good.
anything else you wanted me to talk about? Or? Okay. All right, well, thank you for having me here tonight. And
Can we
hope
ask you
enjoy
a question off the record about something else?
Sure.
How's this concurrent variance thing going?
Well, it was recommended for approval by the Planning Commission. I think on a 4-2 vote. It's
Yes.
coming forward to the
City Council.
City Council.
October 28th.
There's still, October 28th?
October 28th, yes.
And there's still a lot of emails flying back and forth about people who were for it and people who are against it. So I'm not sure what will happen at the City Council level.
City Council was their idea in the first place, wasn't it?
I don't know whose idea it was. I was just asked to prepare it.
Yes. I mean, it initiated from City Council based upon their review of
How do you
many
feel
factors.
about the difference between the efficiency of one body hearing the variances that might go along with the zoning decision, that they kind of go together versus the issue of giving the public more exposure to it, more time, a better chance to provide public comment.
I think in the concurrent variant process, my own feeling is that where you're going to, when it's in conjunction with the rezoning, it probably should be heard through that process, because you have, it goes before the planning commission, and then it goes before the city council. So you're actually having more public comment and more public input in that process than you would if the zoning were to go through, and then
For
later the
variance.
matter would come before the Board of Appeals, really with just one notice and one hearing. And also for the fact that sometimes when the city council would approve something in a rezoning, they're trying to impose conditions or get the agreement of the developer to certain conditions that will ameliorate the effects of the rezoning on the neighbors. But in order to do that, it may require a site plan adoption that would, okay, in order to have a less impact here on a neighbor, we might have to, in another area, change a setback or move into a stream buffer or something like that, which, in consideration of the entire picture, that made sense. But then if you adopt that site plan, and it really has a couple of what would appear to be variances, there still would have to come back to the Board of Zoning Appeals. If the Board of Appeals did not approve the variances, then you've probably got an unconstitutional zoning because it can't be developed under that plan. Or the Board of Appeals feels compelled to grant the variances because, it's already there and it's gone through that process. So, I mean,
I
don't think that
disagree
would be the
because the
case.
planning commission does not require a full-on site plan. So
Well,
we would get,
it
and this is
doesn't-
what I plan on doing, there's no setbacks, there's nothing on there, then it's going to go to council with the same thing.
typically, a site plan is conditioned. It may not be required, but the zoning conditions will include a condition that the development comport substantially with the, site plan dated such and such and such and such. That's very common in rezonings.
But there are no stamped site plans submitted with a planning commission case.
This coming from our ZBA member who just moved over from the planning commission, where he served.
There
for-
is no required,
It may not be required, but, I've seen your cases, and certainly the cases I've worked with in other cities, that there's almost always a site plan that is,
other cities, sure. Might be the case.
well, I mean, your city council has approved rezonings
I mean,
with conditions.
I'll say this much, in terms of the proportion of those that come with the survey and a site plan to those that do not come with all the sort of the minute details of the entire site, the project itself are going to be minor in compared to what we have. I don't know what, in terms of what you may be referring to, but most instances, even when it comes through the planning commission through a rezoning process, even if you looked at the staff recommendation, in most instances, if not all instances up to this point, they have been conditioned to a specific site plan. I don't want to get off topic.
And
into
you don't
the
really,
ZBA, but-
don't get hung up too much on just the site plan.
Mm-hmm.
The condition may not be a site plan, it just may be such, it may be something that says, there'll be a buffer setback or something like that. It may not be, it may be within a text condition as opposed to a reference to a site plan.
Sure, there's many variations in terms of how they could go about initiating what their request may be, in terms of the letter of intent, the application in itself, in conjunction with the site plan. But, that's one of the reasons why that we put in a condition currently, because there is no concurrent variance provision, where it states that it's conditioned to a specific site plan. However, the changes could be brought upon the site plan itself based upon the decision of the zoning board of appeals for a variance that is associated with the request.
I assume the council understands and has seen the amount of time that gets spent at ZBA meetings. That time will then be transferred to the back end of a typical city council meeting. Are they going to go through the same due diligence, the same process, the work sessions specifically for each ZBA case, and follow the same protocols that we've all been trained to follow?
Well, yeah, in terms of the protocol, obviously the training is different, but in terms of the standards that would be applied, the same standards would be applied from the ZBA to city council and those cases. And what I would recommend is it's pretty much the executive summary stated that. The ordinance, the text amendment also stated that fact, that they would have to comply with the same standards applied by the ZBA.
And I think what you're saying is they're not used to those standards, right?
Correct.
So with the hardship standard and this and that we have are not commonly in front of them, so they have to reset their thinking
And their clocks.
and their
To
clocks.
tack on a couple hours
Yep.
at the end of
Yep.
a council meeting.
And it is-
Would you say it's possible that something that they might decide to do a variance, could they grant a variance under this thing that maybe wasn't brought before the planning commission? So could they say, oh, well, we just thought of a great idea, let's fix this problem by making a condition over here, and to give you that condition, now I'll need a variance, okay, we'll give you variance too. Could they be doing?
I would think they would be held to the same standard we are, and that they can't offer up a variance that
Yeah,
hasn't been applied for.
You would be advertising through the zoning procedures law and your own ordinance,
Right, they
of-
couldn't
Right.
create
You know,
a variance
the rezoning.
Yeah, they wouldn't be able to do that.
And
Yeah.
the variances, and you'd have separate signs. And so if something is not included in the notification in terms of a type of variance, then no, they wouldn't
It
be able
still
to do
has
that.
to be the
They'd bound.
applicant's idea.
Yeah.
Okay.
The-
Well, then I think the public is protected, Cory.
Sam, the issue I have with it is and I voiced this last night at the council meeting, is the reduction in public hearings that the public has an opportunity to be at. Currently, if there's a rezoning, they can be at the at the planning commission, and then they can be at the city council meeting. And both times, they have opportunity to speak and support or opposition to what's being done. If, in the case of concurrent variances, or a case that would fall under the concurrent variances, but under our current process, they also would come before the ZBA and have a third opportunity to voice public concerns, right? We're essentially talking about taking away one of those meetings and having everything run through just 2 meetings. And that's the concern I have, is that we have a city full of very busy people who quite often aren't reading the agendas before the meeting actually takes place. And then an article hits the Brookhaven Post and says, this was decided last night, or this case was deferred last night. And then people become aware of it and want to come out and have their say. Well, if it's already gone through the planning commission and they find out about it after the fact, they've lost one of their opportunities to speak. And if they then can't make it to the city council meeting for whatever reason,
Well,
you're
playing
limiting the
devil's
opportunity.
advocate, are you then creating a veto at the zoning board of appeals level?
I don't think you are creating a veto, but I think,
Well, you have the opportunity.
I question why.
Again, there's not, and again, don't get me wrong, there are reasons, I think, on both sides why it would be appropriate or may not be. And it's entirely
Well, and I think I do see
discretionary.
the main reason it would be appropriate is the awareness on the front end of this is a rezoning with a variance. But I
Right.
fail to see why we couldn't have that awareness on the front end and still have the 3 different meetings. That would make sense to me.
Well,
I'm
other people would
actually
argue that there's
surprised
more
that-
efficiency when you address it all as part of one
I think
hearing
it
and
is more
process.
efficient. I don't disagree with that.
But,
I
so,
just don't
you
know
know,
that I think it's
probably not
more
gonna
important
change
to
your
have
mind
the
on that, but
opportunity
I-
for public comment
Yeah,
than it is
I-
to have the efficiency for the developer or landowner, right? Is it really going to matter if it takes another 2 weeks, 3 weeks to get that through the process in the grand scheme of things? I would argue no.
Well, again, you're also
we still have a
creating
much faster
potentially your
process
complete.
than most other cities,
creating
and
a,
certainly
a
faster than what DeKalb
catch-22
County had.
situation where you, are you going to have to approve a variance to make this work? If you don't approve the variance, then the zoning that was probably approved is probably not constitutional because it can't be developed under the, under what
do
the
not
the
disagree
council
with
has
that.
provided.
Mr. Chairman, just in the interest of time, it is 5:30 that we should get into the work session. I know that we sort of, it's a healthy discussion.
Yeah.
It was not something that I was
Yeah, not
thinking
something I
about
was
something that we were
planning
going
to
to discuss tonight, but it's definitely a healthy discussion, and we need to continue to have that discussion.
Yeah.
But just with the interest of time, if we could get into the actual work session, I would greatly appreciate it. And I also want to thank Mr. Thomas for coming in and
Absolutely.
providing the training for us.
Absolutely. Thank you,
And
Mr. Thomas.
You're quite welcome. Thank you.
Thank you.
And I hate to be contrary, but just in all interest of fairness, Mr. Dillard's co-partners are here, so if you'd like to ask them the same question, or if they'd like the opportunity, then that's fine with me, since you asked me a question about why the city might sue you. If she's okay with it, then fine with me.
I think we could touch upon that later on during the public hearing.
I think we're okay.
Yeah.
Thank you, though. Thank you. All right, I did realize after Mr. Thomas started his training that we did skip the call to order.
Yes, sir.
We should go back and do that.
Start the training over.
Yeah, let's start the training over.
The roll call.
Yes, the roll call. Do we need to amend the agenda to be able to do that on the back end, or can we just,
I believe you're fine to just proceeding with the roll call.
okay. Mr. Bolya?
Here.
Ms. Balcom?
Present.
Mr. Beardsley?
Here.
Mr. Self? I'm here. Mr. O'Connell?
Here.
Mr. Clockadale?
Here.
And Mr. Vyers is absent. All right, we will move on to organizational and procedural items.
I'll quickly touch upon that. There's one item, it's related to the amendment to the rules and procedures for the Zoning Board of Appeals. There were several revisions that were considered. One additional request, I believe, was also considered in terms of the actual definition of a quorum, or the number of a quorum. And that's specific to Section 3 of the Rules and Procedures. And I believe our city attorney, Tom Curry, explained by email as well, I don't know if it was shared with everyone, but per the zoning ordinance, under Section 27904, it specifically calls out a quorum as 4 members. In order for us to effectively change the rules and procedures, then we would have to enact the change to amend the zoning ordinance itself. So for that reason, we weren't able to make that effective change on Section 3. The change that we did make was on Section 15, where in which currently the language states that a motion shall require the vote of at least 4 board members. It's been revised to state that a motion shall require the vote of the affirmative vote of a majority of those voting at which quorum is present. So obviously, if there's 4 and we had a quorum, we would need a majority vote, so technically a vote of 3 in order for a motion to pass. So that's the change that took effect. Section 17, specifically Section 17B, subsection 4A, where we do have a current limit for all persons other than parties to speak for a limitation of 3 minutes, but there was no total cap. We did introduce a cap of 10 minutes for the board's consideration. I know there were discussion about, some agreed with the 10 minutes, some did not feel that 10 minutes were appropriate, so that's something that could be discussed. And obviously, we're welcome to any sort of consideration.
So do we need to, we don't need to make any motions or anything of that sort in this meeting, but in the regular meeting?
Correct. In the regular meeting, I would ask that a motion be made one way or the other based upon the discussion and the determination of the board. And that is all for organizational and procedural items.
Do we need to, I don't know if it would fall under organizational procedural items, but the issue we were talking about before the meeting started with one case in particular, do we need to address that at all?
I'm assuming that you're talking about the objections that are going to be made by both parties in the administrative appeal? Is that what you're talking about?
I'm talking about that as well as the I'll just call it out, Mr. Beardsley.
Okay, that's what you're talking about. I wasn't sure what you were talking about before the hearing, if you excuse me. I think that's within your discretion if you want to do it right before that hearing or in the administrative. I do believe that there are going to be
We do it
some
now.
objections, maybe from both parties on a different matter, but.
Yeah,
I believe there will be.
yeah.
We,
On a different matter?
What's the different matter?
Why don't you tell us what the different,
Well,
I know one of
the
the
different
things-
matter that I'm aware of, I had a conversation with Mr. Curry after our last meeting, and the question was raised as to how did we get to a deferral vote, and was that proper at all on the Caldwell Venture case? I believe both councils intend to object to that position tonight.
Right, and I don't feel it's appropriate for us to really get into the merits of whether it is appropriate for you to do that or not. Your counsel will be here to advise you on
Yes.
that.
He's stuck in
We
traffic.
think both
Sure.
both parties are going to object to the deferral?
So I'm told.
Right.
Yes.
I would ask that, again, discussion be reserved, and I believe in terms of how you,
Julie, you're nodding your head?
I don't know if they're going to object to it, but they're going to have a response to
there's a different
maybe the
response.
city's position,
And
to be
that's
fair.
going to be something that could be considered by the board as a whole. And I believe we could sort of proceed with that discussion after we have completed the procedural and organizational aspects related to the
Okay.
procedures.
Just relating to the question as to whether or not the 3-3 tie, what that really means?
Respectfully, we really don't want to get into it until we have it because it may be considered an ex parte communication,
Right.
and
The-
since your counsel isn't here, so.
If you wish to defer the adoption of this until you can hear that argument, then that may be appropriate. That's the only thing that I can suggest, but
The adoption of your new rules is what he's
New
saying. If you
rules.
wish to wait to adopt our new
If you wish
rules
to
until you
wait.
hear that argument.
But we wouldn't adopt that in the work session anyway, right? We would
No.
adopt
No.
it in the.
no. And if you could certainly move it down to, in the agenda if you want to.
Yeah, I don't really feel a need to wait to adopt the rules for this discussion. It's more
And if
just
you,
adding that in as, doesn't need to fall under organizational and
if you,
procedural items.
if you prefer to deal with all the matters under the organizational, I think that's what you're asking, then
Right.
there's not a problem with that as long as
Yeah.
you amend your agenda.
Okay.
How do you plan to raise the issue about? Who's going to bring it up?
I don't know, but I think we need to wait for our legal counsel before we. It's-
Our members have met him, I believe.
Well, let's talk to them before the
He
meeting
was-
starts.
He was met with several months ago by Don, Tim, J-Max.
Yes, they could have a discussion.
Been in the works for a while. He has texted me, by the way, and just said that he is caught in traffic and on his way. In that light, I believe the only unfinished business item that we have relates to a matter that we would like his attendance for. So I would suggest we entertain a motion to,
There's actually 2 items of unfinished business.
yes, thank you, you are correct.
And,
Are we able to move one of those items to a later point in the agenda on the work session?
I don't think we need to. Again, we're not going to get into the merits of unless you're saying that you would like to have discussion with your counsel in regards to that specific case in terms of 48. But, I mean, just like we did last month, where we didn't necessarily get into the merits of the case itself, it's a discussion point at this, in terms
Even
of
without
this
getting into
juncture.
the merits, I don't
Mhm.
feel it's appropriate to discuss even the history of the case without the counsel here to the
Correct.
extent that we're
So
going to
let's-
look to him to advise us on
I
it.
would
So,
suggest we go to ZBA 1454, have Mr.
We just
Song
move on to
give
the next
his-
one, and then
give his-
the actual discussion that you're wanting to hold could be held during the public hearing phase, the regular meeting.
But do we need a motion under the organizational and procedural items to amend that agenda to do that?
No, sir.
Thank you.
All right?
All right, and we will move on to unfinished business. It's ZBA 14-54.
What page is that, Mr. Song?
54 begins on page 320. You're welcome. All right. The ZBA 1454 is a request to increase lot coverage from 35% to 36.9%. It's very similar to a case that had been previously heard by the board of a property off of Shuri Lane. In this particular case, the applicant had submitted for a building permit, was approved from the city, and while proceeding to build, they decided that they needed a larger or wider driveway, and we felt that that should have been considered initially with the overall application in itself, and if that was the case, to submit for a variance prior to the construction taking place on site. And therefore, staff has recommended denial.
All right, any questions from anyone? Go ahead and move on to new business, case ZBA 14-60.
Thank you, Mr. Chairman. Yes.
Point of order, our mayor is yelling into the room.
I was wondering who that was. ZBA 1460, it's a request to reduce the required 10-foot setback for accessory structures to 1.4 feet. In this case, it's accounting, the 1.4 feet is counting for the largest or greatest encroachment into the setback associated with the 10-foot accessory structure setback. The 1.4 feet would cover the encroachment associated with an existing shed, with a newly constructed awning and proposed deck, or deck, in this case, as both structures are existing. The shed in itself has been in existence since, I believe 1960, if I'm correct, which is in the same time period as when the primary structure was constructed. With that said, since that time, the applicant has added an awning addition to the existing shed, and also has constructed a deck. This was all done without a building permit. But again, staff felt that there is a hardship associated with it in terms of the existing layout of both structures. There's only a certain amount of area that could be worked with to accommodate for those structures. And due to the shape of the lot itself, we felt that it would be appropriate for the applicant to be approved of the requested variances.
So, to be clear,
Yes,
that he's already built the deck?
yes,
I'm confused because in the request it says proposed deck.
I understand. We sort of presented in that light, as always, in terms of, it seems like a proposal, but the actual language in the report itself, we wanted to definitely give it the appearance that it is existing. I understand that it says proposed deck in terms of the actual legal notification associated with the request, but the deck is existing. Don't recall necessarily how it came to light. I believe it may have been sort of a code enforcement matter. I'm not sure who made that complaint, but that's how the initial discussion began. One thing to note, the neighbor to the east, which is shown as Lot 15 on page 344, they did provide a letter of support, and that was included in y'all's, in the ZBA packet.
Hey, Ben, to your knowledge, have any building permits been issued for this property over the last 12 months?
Not that I'm aware of. I don't believe from the city directly.
And
I only ask, and no, I was not the person who called, but they had a curb cut. That house was being remodeled over the course of 12 months right on Dresden Road. Curious how a curb cut managed to make it in there, siding, and then this project. It looks like someone at the end of it brought us up to speed. So they're asking for the part that someone must have complained about, but what about the other issues on the property? And I'm not here to hear it, but.
Sure. Well, in terms of the roundabout curb, the additional curb cut, we vetted that, and they're in compliance, and the requirement being that it be 35%. You can't pave more than 35% associated with the driveway in the front yard. And the front yard is determined based upon the front property line to the front facade of the home, extending to the side property line. So just based upon that visual itself, they're well within or under that 35% rule. And that was a separate complaint that did come in, and we vetted that. That's why they're not requesting for a variance.
But you don't, I thought a curb cut required special permits.
No, they just require a separate sort of right-of-way encroachment permit from Public Works.
So there is a separate permit.
Yes.
But you just said there wasn't a separate permit.
No, meaning it's a separate permit, not from planning and zoning specifically, not from
Okay.
community development.
All right.
Is it possible that they received permits from DeKalb County before we incorporated? Do we know when they did this second patio?
I'll be honest with you, it's been a year for me now, but it's been like I've been here for 5 years, so I can't really tell you exactly the timeline. I've been dealing with so much. It was on the earlier part of when I came to the city, but from my recollection, I was dealing specifically with the issue of the additional curb cut on Dresden and the roundabout and the impervious factors that may be associated with that
So
improvement.
it's possible that they received permits from DeKalb County?
It may be possible, it may be from DeKalb, it may be from us, but I believe
Because had they received them, they still wouldn't be on record, correct?
if they received it from DeKalb, we would not have that record. But in terms of the aspects of what they're coming before you in terms of the variance, they did not receive building permits for those items. And that's why it's been placed as a condition.
Do you know if the work that took place in the backyard took place subsequent to your discussions with them about the need for a permit or a need for approval for the driveway?
I don't believe so, because when I was dealing directly with the driveway, it was just the driveway itself. It wasn't with any other sort of structures related to the property. It came after the fact, and the only way I was made aware of it was through a complaint.
I mean, there's definitely a hardship here. You can look and see. My concern is that they got the wrist slapped once and then kept on trucking with projects out there.
Well, they got the wrist slap in terms of the complaint came through. The essential process that we follow, the standard operating procedures for code enforcement is, the first act is a notice of violation, second is a letter of violation, and the third would be a citation. In this case, it was a notice of violation that was issued to them, notifying them that they would have to submit for a variance. It just took a long time to get to this point from the point of origination in terms of when they started doing the renovations, I believe, because I believe they had some personal matters that they were attending to. But it never came to the point of us issuing a citation.
But they continued the renovations throughout that period.
Well, like I said, I don't know what the timeline is between the renovation and its association with these additional improvements that they made in the rear yard.
Let me rephrase. They were allowed to, we didn't issue a stop work order, right? They didn't have to stop.
Right.
It was a.
What I would say is, I don't necessarily know if they received a permit or not for the interior renovations. It depends on what they were doing. I don't know if it was interior, exterior. I would have to look into it in order to tell you and to confirm exactly what they have may have not received from us. And that could be a question that is directed to the applicant and see if they've received permits from either us or DeKalb County, depending on the timeline.
All right. Any further questions? Move on. ZBA 14-61.
All right, ZBA 1461, it's a request to allow for 2 8-foot-tall retaining walls along Kusawati Drive and to allow for an existing impervious encroachment to remain within the 50-foot transitional buffer. Currently, it's an existing property that contains 9 apartment buildings, and it's zone RM75. The intent of the applicant is to convert those apartments into townhomes, I believe consisting of about 42 townhome units. And the request for the retaining wall itself would occur in a location that has a very steep grade along Kusawati Drive. And this would provide for the stabilization associated with erosion, as well as the location that they're proposing to provide the detention pond So in essence, it's just an added feature, support feature to that. And let me just get to the site plan. And the site plan is shown on page 362. And it's in real small font that it's a little difficult to locate.
Talking about this one, Ben?
Yes, sir, that is correct. So if you look along Kusawati, and it's hard to differentiate between the two lines around it. Do you have it up?
You're about to tell us where these walls are on this picture?
Highlight, they run real parallel on the right-hand side. Next
They're
to the-
along Kusawati?
Jed, if you were to look at the screen, Rhonda, if you could just point with your cursor. Oh,
Okay, thanks.
Look at you.
yeah, yes, Mr. Beersley. Bennett's up here pointing it for you.
Okay.
This is high, Kusawati's low. This provides a grade transition down from the townhomes down to Kusawati.
Could you do it on that one?
Absolutely.
Yeah. And he's just tall enough to reach it as well, so.
So the development is higher than Kusawati, and the line is one wall, that line's another wall. Provides steps down from the elevation of this down to Kusawati. It also provides a separation that protects this existing very large storm sewer pipe. The developer's engineer has met with Public Works and staff, and Public Works is in agreement with the concept. Construction in order to protect the pipe. That's the situation. Two walls that parallel Kusawati, parallel an existing storm pipe that provide for separation and elevation from the elevation of Kusawati up to the townhomes.
Could you go to the, I'm sorry,
Oh, the wall detail?
yeah,
Okay. Do you have the wall detail around?
just the next page.
Elevation?
Yeah.
File from the one page.
Does the city count the height of a retaining wall based on what's exposed or the overall height? Because it looks like it's about 16 feet tall with then 8 feet of it backfilled.
Yeah, it's what's exposed from the finish, you would say the finish grade to the height, the top point of the wall itself.
Pardon me if it's not clear to me, and maybe I didn't study enough, but what exactly are we giving a variance against to
Oh.
allow the walls?
Sure. What, the provision that they're requesting a variance from is the retaining wall, any new retaining wall is only allowed a height of 4 feet.
Okay.
Okay? They could go up to 6 feet through administrative variance.
Okay.
They could go up to a maximum of 8 feet through a variance process here.
So the retaining wall limit is
It's based on the height.
4 by ordinance, 6, 50% admin leeway,
Correct.
and 8 is the max.
Right.
Essentially, what they're saying is without those retaining walls, they couldn't construct that section of townhomes.
Correct. And if you had a chance to go out to that site, it is fairly steep along Kusawati. There's a steep drop-off on that end. The second component to this variance request was to allow for the existing encroachment, impervious encroachment to remain within the 50-foot transitional buffer. Currently, it's being used as an access drive
Where is that
around.
on the picture?
It's right back here.
Okay.
This area right here.
I'm sorry, Ben, where?
So currently, it's being used as an access point to access additional apartment complexes. We felt that based upon the site plan that they have provided, don't necessarily see a use that'd be appropriate for it. We felt that, again, it's not necessarily a hardship by any means. And although we have recommended approval of the retaining walls, we did recommend denying the impervious encroachment.
Well, it'll no longer be used for circulation or they show their curb cut ending stubbing in there.
Yeah, there's no, it wasn't specified as to what that intended use would be for that area. But essentially, it would function as a rear yard for those townhomes or possibly common area, open space, whatever it may be.
Could be they're thinking about just saving the money of tearing it up or maybe putting a playground on it or something.
Right, and again, it wasn't very clear. There was no direction in terms of the application itself.
We can certainly ask them.
Yeah,
Correct.
Absolutely.
Okay.
And Ben, just for
Yes.
clarification, that is outside of the stream buffer, but in a 50-foot,
Transitional buffer?
Transition.
Yes, because it abuts up against single-family zoning
okay.
and single-family detached use.
I guess I don't really understand why they need a variance to be able to leave it then.
Essentially because under the requirement, technically, we can't necessarily account for what was existing and what the requirements, the zoning requirements were at that time when the apartments were built. Because with the effective change in the use of the property in itself, the entire, I guess, the current ordinance would have to be complied with. And therefore, it calls for a 50-foot transitional buffer. Typically, what the 50-foot transitional buffer also states that if it's sparsely vegetated, then you would have to replant. Doesn't allow for any additional sort of driveway. It's very specific, and I'll get to the language, but, and that's the reason why that they're seeking this variance.
Basically, like, they're starting over,
Essentially, it's a new development,
Yeah.
and they'll have to comply with the current standards.
grandfathering.
See it. I got it. Okay. Any further questions? Let's move on to ZBA 14-62.
ZBA 1462 is a request to reduce the rear yard setback from 30 feet to 4 feet for proposed porch and deck addition. The existing home, as you can see, obviously it's a large footprint on a small lot. The zoning of the property surprisingly is RM 100. RM 100 requires, in terms of impervious coverage, is associated with the building only. It's not necessarily impervious coverage associated with a patio or a driveway. So in that regard, they're meeting the impervious coverage, they're not exceeding the maximum of 35%, again, which is limited to buildings only. That said, they do have an existing patio, deck that they're looking to expand slightly, but also to, I believe one portion, apologize, just 1 second.
Oh, you're looking, Ben.
Yeah.
You know, the drawing looks like it's
Porch.
6 feet, and their write-up says 6 feet, so do they really,
Yeah,
are they really only asking for down to 6 feet?
no, 6 feet is incorrect. In terms of the way they're measuring it, it's not necessarily a perpendicular measurement from the property line. And therefore, the actual distance from the property line is much closer than what they've represented. And as measured by staff, it appears to be 4 feet of separation only. Okay. And what I was getting at, it is essentially what they're wanting to do is convert their deck into a screened porch and then extend it out a little bit further towards the northern end for a smaller deck addition. There was, prior to me getting into sort of the comments that we received, just quickly speaking, if you had a chance to go out to the site, again, larger homes, smaller lots, it appears to be a cluster development. Patios and decks are actually encroaching and somewhat encroaching on the visibility of adjacent lots as well as it currently exists. Not just on the current subject property, but also the adjacent properties as well. They run into very similar setback issues. Based upon that, we felt that, it's not necessarily, that it did not go beyond the minimum required, that it was not a special privilege, and felt that the request in itself would be appropriate, and we did recommend approval. But I wanted to quickly highlight that it was included in your packet. There was one email specifically in opposition, referring to the fact that it would be a further encroachment onto the privacy of the adjacent neighbor, and that letter provided in the packet was from the property to the north. And I believe they provided pictures from their perspective. Another email that I forwarded to the board on Monday was from the property owner to the south, who again has a very similar situation with the subject property and to the neighbor to the north, with the subject property and the person to the south. The neighbor to the south did ask that the board consider possibly, if it was to be approved, considering a condition of adding what they refer to as Italian cypress trees along the southern property line. So I just wanted to bring that to your attention.
So Ben, you mentioned the impervious coverage criteria is different in the RM100.
Yes.
And applies only to the house. If they enclose the deck, is that considered part of the house at that point? I would think it would be as an enclosed deck.
In terms of the enclosure, yes. The portion of what they're enclosing, yes, that would count against their lot coverage.
So with the existing house and the proposed enclosure, there's still not an issue with the impervious coverage?
They're hovering near the 35, but they're not exceeding it.
Okay, thank you.
I'm sorry, Ben, real quick, what's the difference between an RM75 and an RM100 as far as lot coverage? I mean, I thought decks and porches counted against your,
Well, typically speaking, like an R75, R100, in comparison to an RM75 or RM100, there's a difference in terms of lot coverage. The individual single-family R100, R75s is 35% lot coverage associated with all impervious coverage,
including decks
including
and
driveway,
patios?
decks,
Okay.
and so forth.
So
But
an RM, it doesn't count those?
it's just associated with the building,
Really?
yes. So typically, what you'll find in RM100s, RM75 are your typical multifamily developments,
Sure.
where they have an expanse of impervious coverage. And in those instances, per the ordinance, it only accounts for buildings.
Lot is the Zaleski lot?
If you're referring, Selesky is the neighbor to the north, where it says Lot 24,
24 is Zaleski?
Where is it?
yes.
Ben, what page is that? Provided from his lot? That
From,
last
yes, from
picture?
their lot, right. The pictures that are provided in the packet is
Ones in
from their
color?
perspective. Mhm.
And
So-
the fellow who wants the trees is 32?
The fellow who wants the trees, let me get to the site plan.
Ben, is this from a visual, is this the one,
Yes,
the
from
ones, the ones with the
sele-
trees?
No. That's from the property to the north who has requested that the board deny.
It says, is this Zaleski?
Selesky, yes.
So just make sure I'm right, the patio's not going towards their house, it's going outward.
No, it is actually going towards their
Yeah,
house.
Okay, I want to make
yes.
sure I got the visual
Yes.
reference right.
And the best way to sort of compare would be, Rhonda, if you could go to the as-built real quick.
Okay, here we go.
So just look at the extent of the deck here in relation to the back of the home. You see there's,
Yeah.
so this is as-built. If you go to the proposal. So you see right here?
Yeah.
So the extent of the original deck, farther, in addition to that, having steps. But the perspective of staff is, the only violation in this regard would be associated with the rear yard setback. In terms of the side yard, even with the extension, they're still within the 7.5 feet.
So we're basically giving in a variance for an existing condition.
Yes, I mean, we have to take into consideration, again, there's a modification, it's an expansion of the
No, I know,
footprint, but yes.
essentially, the only encroachment is an existing structure.
Correct, and this is your 30-foot rear yard setback line.
And
which
it's
bisects the
closer than
house.
it might appear to the property owner because their fence is so far off.
And the thing is, yes.
Does that bother you, the fence being so far canted, twisted off the property line?
Yes, and it's a, I'll just leave it at that, it's a civil matter. But at this point, look, we looked in to see if we could find any conditions associated with the property to see why there's such a discrepancy in terms of the setback itself. that we find it a little odd that you will find the rear yard setback bisecting the
10
house.
feet from the fence.
So there may be some issues, but we did not find any evidence of an actual zoning or rezoning that may have taken place.
Ben, it looks like, when I went and visited the property, it looks like the people directly behind them have a porch.
This guy.
How far, did you know how far, I don't want to go creeping in someone's backyard, but do you see how far that is from that property line?
Well, if you were to take into consideration that fence and the location of the fence.
Yeah.
Going out there and seeing it for myself, that neighbor that you're referring to is actually fairly close to that fence.
Yeah, it's, so if I'm, oh, God, you mind?
It's right here. You're referring to.
Yeah, okay, yeah, that's the,
And
Yeah.
the way you look at it, their deck is actually fairly close to that fence line. But in essence, if you look at the property line, obviously, farther set back. It just gives that perspective because again, the proximity of the porch to the fence. But as you can see, the fence is encroaching onto the neighbor's property.
I got you.
I think the point I was just making to Hope is that if you looked at the encroachment that looks like, that's really 6 feet, if you were in the backyard looking at, comparing it to the fence, it would seem like 10 feet or
Sure,
roughly.
sure.
The space between the deck and the fence
The
is
location of
10
the
feet.
fence throws it off in terms
Right.
of how you see it on paper compared to what you see on site.
Absolutely.
But in terms of the impact of this, I'm
Get a longer pen.
You got a step
sorry. Come the other way.
Other way, other way.
Come down. Yes, please come down.
Needs to be able to reach it.
Go up then. Yes, go up.
These people
Still new,
don't
we
want
gotta
it at
give her
all.
the benefit.
I think she just likes playing.
They don't want
What I was gonna say is,
It's gonna come out
the
this way.
impact of this,
They don't want it.
porch
That's right.
itself is very
Because
similar to
that's
the
the
impact
right
of this
there.
porch
That's-
on
okay,
this
here's the
neighbor.
picture there.
The other people just said we
Again,
plant
that's
some
why we
trees.
felt that it's not necessarily a special privilege.
Yeah, you're looking from the people who don't want it.
Yep, so I'm looking at that one.
As stated, it is
It
related.
says Gillespie's lot is at the top of the picture.
Gillespie's up there, but the
Yeah.
other, the person who asked for the line of trees to be planted
Yeah.
is this neighbor right here.
Oh, it wasn't the guy with the fence that's all.
Do they have an enclosed porch there?
Subject to
No, it's an open
23,
porch.
right?
An open porch.
Yes.
Right.
But when you
It's a-
say
it's a
it's
deck.
not,
There you go.
okay,
Ask your neighbor.
The deck.
okay,
Okay, wait.
all right.
Build this much of a deck right
Okay.
here.
Maybe grill outside of your,
Not on the property.
Yeah.
when I built my screen porch, I just put a little deck
It's
outside.
kind of like your setup with your grill outside of your enclosed.
Yeah.
Yeah, that's what I have. It's called a grilling
Nice
porch.
setup.
All right, is there any other,
I didn't get it
any other
I think we're
questions?
still
Okay.
getting some clarification here.
Benefits is built for this guy.
Yes.
By the
Chairman, I
same
saw
people
the,
who owns
our
this,
counsel here.
Yes, I've just sent him a message to ask if he could step back in, but I don't know. All council appears to have left the room, so.
I believe they're convening in the council conference room,
Our guy.
so.
So it's not within our purview to condition this on moving the fence, for example.
Oh,
Fence
no,
basis.
no, no.
we can finish.
Again, I don't necessarily think we should get involved in that matter. It's definitely a civil matter at this point, for the two neighbors to work out that difference.
But you recommend approval is the bottom line.
Yes, yes. And again, our measurement is purely from the property line.
Are the neighbors aware of that issue?
Uh,
Do we know?
If they weren't, I'm sure they are now. Because I believe they had to share this with their HOA.
Okay,
So again, I don't know what the process is internally of their subdivision, but I'm sure just by the visual itself,
okay,
they'll be aware.
That's
Very good.
from the.
But we haven't received any comment from them.
okay.
Real quick, Ben, this structure is coming down and a new one's being replaced.
Correct. From what they stated in their letter of intent, they said that it's not structurally sound, they have to rebuild it.
How does this different from the prior case where we used the example of starting from scratch or not being able to quote-unquote grandfather something in? Is it different?
Well, no, and it's similar, and that's why we're making them come in for this variance. If they're within their footprint, it would not be a major issue, but they are expanding it.
Point is, they're really expanding to the side, but they're not encroaching in the side variance.
Correct.
So why did you recommend approval?
Again, we felt that it's a similar situation with the homes within that area. It definitely is a hardship, as you can see from the setback itself, it bisects the house. I don't think, we felt that it's not necessarily a special privilege by any means from what's existing within that neighborhood.
Well, the house is probably within 30 feet of the property line too, so.
Yeah, it's obvious right there, so.
I noticed, and we can ask the applicant, the deck south is proposing a 16 by 16 deck. Oh. Screen porch.
Yeah, screen
New screen
porch.
porch would be 16 feet by 16 feet. The deck itself currently is not 16 feet, they're showing us
12
12.
by 17.
They are extending it farther. It's winding out, and that's why that corner.
It's deeper and wider?
I
It's
believe-
only got a
Right there, it shows
12-foot
12.
Yeah, and the thing is, sorry, could you go back to the site plan?
Eyes there.
Yeah, I had a similar question in that it didn't seem like their plans matched up with the dimensions if you were to scale out the deck on the site plan. But whatever the case may be, if it is approved, they are going to be limited to the footprint as represented in their site plan.
But the stairs aren't on the site plan?
That's technically fine. I mean, they're within their 7.5-foot setback, even with the inclusion of the stairs. And the way I go about measuring that is by, the stairs would extend to the farthest corner on the north end of the property.
Are they on impervious surface? Did that come up?
Yes, it did come up. And impervious surface for this zoning district, which is RM 100, is 35% for the building only, not for,
So this little patio, they got the bricks and stuff?
yes, the patio would not count against the lot coverage, nor would the driveway.
Lucky for them.
Nor would the deck until the
Nor
point
would
that
the
they
deck.
enclose it.
Yes.
So, just to follow up on a comment you made just a moment ago, you said that the footprint is essentially the same, so it wouldn't really matter. But at the same time, I think to Mr. O'Connell's point, they're tearing that down.
Yeah.
So I think they would have to apply for the variance for the
What-
sole reason that they're tearing it down and need to come into conformance,
Right.
right?
I mean, generally speaking, if they were to tear this something down and if they're going within their same footprint and they were to show that per a survey, generally speaking, there are provisions where that could be possible.
Okay.
But they're rebuilding, but also extending, and that's why
Right.
we were bringing them in.
Okay. All right.
Got it. So if they weren't extending, we wouldn't be here.
It's a case by case, and we'll have to see what they could provide for us in terms of an as-built and a proposed.
Then my other question, on their site plan, they have, I believe it's upside down on there, but it
Yes.
says impervious instead of impervious and the
Yes.
calculations.
Yes.
Who did those calculations?
The impervious, I believe, was done by their.
By the it wasn't by the
It's either
city.
it wasn't done by staff, and that's why it shows that it's exceeding, and that's why I had one of our staff members, our staff planners, to go back and measure, scale it out and measure the footprint of the building, and make sure that it's not exceeding 35%.
Okay. And that, when you rescaled it, that included the proposed
Yes.
screen porch?
And they would also be
That was
required,
hovering.
they would also be required when they come in for their building permit to show the correct lot coverage as well, and show that they're in compliance.
Oh, okay. So at the time of application, they'll have to have the engineer.
Because, yeah,
the
they did not
homeowner.
apply for that in terms of a variance request, nor are we considering it.
Right.
But we wanted to do the due diligence to make sure that we could, with the best of our abilities, with the information provided, but they would have to show that as
And
part of the building
that's my
permit.
concern, is if they are hovering at the 35 and they later find out that they're over, but
Right.
they haven't requested that.
Right,
They would just
and-
have to come back in.
They would have to come back in at that time.
All right.
Mr. Chairman, I move we adjourn this meeting.
We cannot yet adjourn. We need to go back to unfinished business for case number ZBA 14-48 Caldwell Venture. Let me just grab counsel.
What's that password again?
I believe you
EV.
may have updated your password, though.
Yeah, everyone's expired last month.
Yeah.
I never had one.
Hmm?
I never had one.
Oh, they never got you in last month? Yeah, they did. Brad signed you in under his ID.
They may say I have to set a new one, but at least. All caps,
No, just the capital B,
P, R,
lowercase.
HPN 201.
H,
Brookhaven, take out the vowels. Is Brad here? I just wanted to give me an administrative download on Google Earth. Brad,
You
can
can
you
go to Google Maps and you can
does the same thing?
Satellite view.
Okay,
Yeah.
okay.
use it all the time.
Last meeting,
Thank you, buddy.
last meeting, Brad signed in under Brad's name so he could have access to it, but anything else you need?
I think that'll do it. A cup of coffee.
I don't know why I felt
You didn't miss
compelled-
much for the work session. It's one page that,
felt compelled to make that request for you.
Okay.
well, council is coming back out here momentarily. They're finishing up a conversation briefly.
So Google Maps will you don't need to download, you just need to access.
And then you choose
Just use
satellite view.
satellite.
Basically the same thing. There. For satellite view. And you go like this.
Like it.
I do.
Oh, yeah.
like
Is that the
it.
6+?
Yeah, it's so funny, I look at the right there.
Check that out. My daughter.
Oh, that's nice.
Check out Lily.
The width fits, it's just.
Got her name up.
Longer, yeah.
I just wonder if that's there, because sometimes I do put it
Mhm.
here. I'm like,
Just
Right, my
three.
husband was gonna get it.
3. A little over 3. You give her smaller, she'll wear anything.
How much smaller is this set? It's bigger than that still.
Yeah.
I'll have to switch over at some point. You just signed up.
All right, this apartment complex is
Okay, and then you just signed up.
Heard my name called.
yeah. I had a question, and they said,
So he just transitioned.
I was trying to download Google Earth and needed an administrator, and they said I didn't need it because I could do Google Maps. And
I don't understand why people. Without waiting in line. Is, and then. What do you?
Color-wise, it's still white and black.
So there's 3 options. There's.
Uh-oh, what's this doing
I think this is the case.
with the computer?
Silver and gold, and they both have white faces. I got the gold.
somebody's got it on TV?
It's all the way down to my office.
It's called Ghost Town. Hey, Mr. Amazing, can I
Really? How
Did you
why
really?
Did you hear it?
That's fabulous.
Web broadcast.
promise that?
Who's
Yeah.
got the web broadcast?
If we can go ahead and move to case number ZBA 14-48. Mr. Song?
That case is a case that would defer to our legal counsel. Their legal counsel, there we go. Mr. Smith.
So our legal counsel will now step into the role that you would otherwise fill, is that right?
Sure.
Okay.
That's just the way I like it.
Sooner or later, we'll figure this all out, right?
You ready?
We're ready.
Okay. Well, a couple things. Number one is, I was just handed a letter that was just submitted today by counsel for the applicant, and I obviously have not had a chance to review it. And I know the city has some objections to whether or not the procedures, that maybe there's already been a vote, and so any vote tonight would be, under Robert's Rules of Order, has been nullified. Then obviously, then there are the other issues that are, that had been raised previously that we were prepared to talk about, and I could certainly talk about those. We did review the Caldwell appeal record. We believe that the decision letter from Mr. Song, when he quoted 349.3 refers to PC2, we believe he should have used 350.3, which speaks directly to PC2. So that, we believe that's just a scrivener's error, and it's not substantive. It does not change the legal argument because the proper ordinance section 27-350.3 contains the exact language quoted in Mr. Song's rejection letter as the legal basis for the rejection of the application. In reviewing the record, there seem to be several issues on the appeal to which need to be addressed. One is the property owner subject to be rezoning must be identified, so the appeal must be denied based on failure to include each of the 8 property owners subjected to the rezoning. Then in the form labeled the property owner's notarized certification, the question is, what is the subject property? Does it include the boundaries of only the applicant's parcel or the site plan condition boundaries set in 2006 when it was rezoned? I agree with the city's interpretation that the subject property is the boundaries of the entire site plan condition property upon which applicant seeks the change. An interpretation of the ordinance, as applicant argues, would render an absurd result that applicant desires a change to the conditions of the site plan, yet refuses to include the property owners of the very site plan he wants changed, or they want changed. We believe applicant's appeal must be denied because applicant must proceed with an application for rezoning under ordinance 27-350.3, not under the change to the official zoning map, section 27-845B. Applicant seeks to completely change and prevent the site plan and entire development on which the zoning is conditioned, yet desires to do it without identifying or including authorization of the owners of the entire site plan he requests change. The applicants in 06 rezoning acted as one ownership entity and remained conditioned to that site plan as one entity until rezoning establishes otherwise. 845B applies to the procedure for changes to the official zoning map, not a rezoning under 27-649.3. We also believe that applicant's argument that 27-650.3 does not apply because he does not seek to rezone to PC2 district is inaccurate, as this section applies to rezoning to this particular district, not simply when you're rezoning from one district to PC2. This is not an ambiguity as alleged by appellant, but merely creative argument forged by the appellant. Now, there were a couple of other issues that were raised. If y'all want to talk about those.
Can you just tell me what you were just reading from?
Yeah, what, I'm sorry, we weren't introduced to you. I mean, I honestly, I don't know your name.
Oh, well, I'm
If we could
sorry.
Back up.
Oh, I'm sorry. My name is Ray Smith. I'm the attorney who was employed just the other day to represent the ZBA. When there's an appeal like this, when there appears to be a conflict with the city, you know, before you all have to make a decision as to whether or not to hear the appeal tonight, or do as the city has recommended that the appeal not go forward because of Robert's Rules of Order, and there are several items there. Would y'all like to hear
Cutting
those?
to the chase, is the city arguing that because it wasn't approved, it therefore was denied?
Correct,
Okay.
correct. It was a tie.
So therefore, it was not approved, and therefore, case is over.
Correct, correct. And that this has not been noticed and that kind of thing. And apparently, I understand that the applicant was offered the opportunity to kind of start over, if you will, and then they refused to do that.
To start over.
Meaning that we could, to try to, because
The
there's
rest
so
of the
many.
board isn't aware of that conversation, but Mr. Curry had approached Mr. Dillard and offered to start from the beginning and rehear the entire case due to some of the issues, namely the deferral of the vote to this meeting, which by the city's account should not have happened. The abstention of one of our board members who was sitting here when our rules prohibit such an abstention. There were a couple issues that led the city to kind of offer up the opportunity to just start fresh, repost for a date in November. And I don't know that I ever heard that the applicant had turned down that request, but I hadn't heard that it had been rescheduled either, so. Absolutely.
Well,
I would love to hear your side of it.
Well,
You need to
Well,
introduce yourself.
thank you.
Hold on, let's just back up.
yeah. Oh, well.
Let's ask Mr. Smith, are we able to hear from the applicant's attorney in a work session, or do we need to wait?
Well,
for
I think that would be more proper in the actual hearing itself.
Thank you. We'll wait, Ms. Sellers.
Okay.
Thank you. But I would love to hear from you in the regular hearing.
Okay, thank you. We
No
appreciate
doubt.
the opportunity.
No doubt we will.
Yes. Okay. So you were saying you've been informed that the applicant declined that request.
Right.
That opportunity.
They, apparently the city attorney offered to kind of give a fresh start, renotice the process. It would be another 60 days, and kind of clean up the issues that have been raised and such, and give the full board the opportunity to hear it, and kind of a do-over, if you will, a mulligan. So,
All it takes is
All right.
time.
right. So,
So, do you have a recommendation for us?
well, I mean, my recommendation, as an attorney and as a courtroom attorney, to me, I think you always want to err on the side of giving the applicant the benefit of having their day in court, so to speak. But again, it's hard for me to tell because I've not known exactly what's happened before. If you all think the case has been vetted and they've had adequate time to be heard and that type of thing, then I would say you probably should follow the city's direction.
We've
If you
heard it
don't-
twice. We've heard the case twice.
Yeah, if you've heard it before, you know what the issues are, you feel fully confident that in your position, then I would say that you follow the city's attorney's recommendation.
And that recommendation tonight would be to not even hear the case tonight,
Right, it would be pulled from the agenda, as I understand it.
because the deferral vote at last month's hearing
Right, correct.
Was unauthorized by our
Yeah.
rule. Yeah.
is essentially void.
Right.
Or was interpreted by the city as a decision.
Right,
And I'm not sure.
Well, the failure of the other vote would be interpreted as a decision. The deferral vote,
Correct.
Their
The deferral
position
vote's
would be,
void
would have
because
never, never
The decision
taken
was made
place.
with the 3-3
Right.
tie.
Right,
And there are
and-
questions about whether or not the 3-3 tie and me sitting up here during that, I mean, I think there's a number of issues here.
Yeah.
And going beyond that, can the council opine on whether, if we go to the actual base question here of whether or not you would have recommended the board vote in favor of allowing the city to take this issue up again, or you would have recommended that we not, in fact, allow the city to take the position again, the original city position that we actually voted on that was tied?
well, it appears that the city that the city acted appropriately. So,
Your recommendation is that the original recommendation,
right,
your opinion is that the original recommendation of the city to not allow the applicant to have their day in court, so to speak.
Right.
And vote, another vote before the city council, your recommendation is that should be upheld.
right, correct.
Mulligan would be that the deferral vote is quashed.
Right.
And the failure to pass,
they
the
they've declined.
failure to approve the appeal be treated as a denial.
Right.
Now, clarify for us, please, the options of the applicant or appellant in this situation.
Well, the applicant is, as I understand it, within the 30 days that they can appeal, file their petition for writ certiorari.
When does that period start? At the last meeting or at this meeting?
It started at the last meeting, as I understand it, yes.
Aren't we really just, though, tonight determining that it was a rejection?
Right, correct.
Be the appeal starts tonight?
Right, well, yeah, I mean, they would certainly argue that.
Yeah.
And I
They
think they're
probably
probably
wouldn't.
within their rights to do that.
And they probably, if they're smart, would just file it by October 28th.
Well, yeah, exactly. Yeah, I know if I were in their shoes, I would probably go ahead and file it. Yeah,
That's easier than
yeah.
arguing.
Than having a pissing contest over that.
So if we were to remove the item from the agenda tonight, how would we go about doing that administratively? Do we make a motion and vote in this session? Do we do that in the regular hearing?
I think it needs to be done in the regular hearing.
But still, how does it come up?
Well, I think at the point that we would introduce the case, we would take a vote.
Somebody would
that
call
time.
for a.
Make a motion.
Somebody would need to make a motion.
Does our vote to remove it from the agenda raise another issue? Is that going to lead to further issues? The fact that we are voting tonight to deny both sides the opportunity to argue again?
Arguably, or you could just remove it from the agenda and say the case has already been decided.
So query, if we had a vote, would Mr. Connell be able to vote on that? Because
Or Mr. O'Connell?
O'Connell? O'Connell too?
Him too.
All right. Jeff,
Excuse me, I'm sorry.
would Jeff be able to vote?
Um,
Get a vote?
Excuse me, yes, he would. I believe that
Yeah, I believe he would have to.
yeah.
Right, because we're not allowed to abstain.
Abstention's not an option.
Right. As long as they've been duly sworn in, then yes.
Well, this part about that you can't recuse, is that because it's an administrative appeal and not a
No, that's
variance?
because there's no conflict.
No, there has to be an actual conflict. There are definitions in the Brookhaven Code that talk about recusal.
You can,
It's like,
he could
I wouldn't have to
recuse but not
recuse 'cause there's
abstain,
no
correct?
Real conflict on.
Mr. Smith, I'm not sure if
He
the
could
history on
recuse but not
this.
abstain.
I was appointed to the Zoning Board of Appeals, and hadn't completed the requisite training the first time this case was heard. So I was advised by staff that I would be unable to participate in the vote at the last hearing because I wasn't a sitting member of the board at that time. So I came to the hearing completely unprepared to make any sort of decision based on the case. But the question was put out to the appellant's attorney as to whether or not he objected to me voting on the case, and he said no, but I was in no position to make any decision on the case without having any involvement in it prior.
So did you vote?
No, I didn't recuse myself because there wasn't a conflict, but I wasn't in a position to make a vote. It would not, in my opinion, have been prudent to vote on something. So I quote-unquote abstained, which apparently is not an option.
Well, yeah, I guess at that point, you're just not qualified to vote yet.
Correct.
So it doesn't really, it's
But-
like you don't exist yet.
But the question is then why was I allowed to sit up here during that hearing if I wasn't going to be making a vote? I think that's one of the issues that'll come up, or that has come up.
Well, again, it's hard for me to Monday morning quarterback at this point
Sure.
on something like that, so.
But going forward tonight, we're all in agreement that Mr. O'Connell could vote on this case,
Yes.
whether it's heard or whether the motion is to
Right.
just say it's already been decided and move on. But we would need a motion to say that it's been decided and remove
Yeah,
it from the
I would
agenda.
probably want to confer with city council, or the city's council, to ask them, because they were the ones that presented this literally this afternoon. So I would probably want to confer with them to ask them just what they thought about that.
Okay.
Mr. Smith, so procedurally, if it was voted on to remove it from the agenda today, then how do we go back and amend the minutes from the previous meeting where the vote and the deferral and all that was made?
Well, I guess you could go back and make a notation on the minutes that it was determined subsequent that vote was a final vote.
I believe my only remaining question is, we've just told Ms. Sellers that the work session is not the appropriate time to address why they did or did not decline the opportunity to rehear the case, and that would
Right.
fall in the regular meeting. Can we do that in the regular meeting and then still?
Well, if we will pull it from the agenda prior to the meeting, if city's council thinks that's appropriate, then you may want to give her opportunity to be heard here.
No, I mean, if we're gonna pull it from the agenda, that requires a vote, I think. I'm not comfortable just doing
But that
without a vote.
requires a vote in the regular hearing.
Can council stipulate on this point for us? Can you guys agree on this? Just get together and agree on how we want us to handle this, and then maybe we won't have to take a vote.
My understanding, and please correct me if I'm wrong, is that you would prefer to us to have an open discussion where you are allowed to present your case and we're allowed to present our case during the regular meeting, and we don't have any objection to that, and the opportunity to respond to all of this, so.
We were about 3 hours ago, maybe, so. We understood.
Ms. Sellers, could you go to the microphone so it's in the record?
We understood the issue to be whether or not to reopen the public hearing tonight.
Right.
Or move forward. So that's the issue. So I do think that I would appreciate the opportunity, and it would probably be more appropriate for Mr. Dillard to address exactly the conversation that he and Mr. Curry had. I think that from what I have learned this evening in talking to Mr. Curry, I do believe that there was a breakdown in communication. I do not think that Mr. Dillard, I know I certainly did not understand the message that was just a phone conversation to be that there were procedural concerns and that there was an opportunity to just renotice this to clear up any procedural concerns. This is something I learned about tonight. So, I would love to be able to work, and I'm happy, I mean, that's what we were trying to do, talking, back there to see if we can come up with some kind of, some sort of a resolution, but I'm really, I think on behalf of my client, I certainly would hope that we'd have the opportunity to be heard. I would certainly, not want you all to just make a decision to pull an agenda item and do that without even hearing our response, because clearly you all have received input from the city as to their concerns and haven't had the benefit of why we don't agree with that. And I can tell you, we don't agree with that. We don't think that the actions that you took last week were in fact a denial based on your rules. So without having the opportunity to really walk you through our position on that, I do feel like we're put at a disadvantage.
And does the city council have,
Come on, Emily, come on.
do you have any
Answer your
objection?
question, we have no objection to stipulating that you all can vote on this during the organizational part or right before the hearing, whichever you prefer, and allow both sides the opportunity to put their case forward on their side.
What case would we be hearing at that point? The
Well-
case to what? To agree with you or to agree with her? I mean, we're here, I mean, the case presented to us is the Caldwell case.
If it were me, I would do it in the organizational part,
Again, what's the case? What are you going to present
It
to us?
would be an opportunity for,
Well-
for both parties to address whether or not it should be heard tonight,
All right,
whether this
well,
case should be heard tonight.
I mean, procedurally, when you would call the case, what I had anticipated in doing was, prior to the time that you started, was to make an objection or make an motion to the effect that the case had already been terminated by virtue of the action by the tie vote that had been taken at the last meeting, and then go through the explanation as to why that was the case. And then they certainly could argue the contrary of the case that was there. It's also my view that should you choose to hear it, then that's fine. I think everybody then has had open eyes, and you can choose what you wish to choose to do and hear it and make a decision. The one thing that we continue to argue is really the merits of the case and why the city is taking the position that it's taking with regard to seeking variances that affect other property owners that aren't part of the application. That's the issue. They would like to address that issue because they feel like that was sort of, curveballed at them at the last minute, and they want to do that too. We have no problem with that whatsoever. But I think it gets down to we're making procedural objections. If they're valid, you can make that determination. If you think not, and you want to hear it, I'm fine with that too.
I have an idea. I'd like to ask Mr. Smith.
Okay, sure.
What about this meeting, at this work session, we could determine that we want to add an agenda item, which said the agenda item will be to hear from both council on whether or not to delete that unfinished business item, or alternatively put, to determine that, that case has already been decided.
Right.
So instead of deleting that as agenda item, to give them an opportunity to be heard in the public hearing, maybe we need to add an agenda item. And I'm just asking that.
I think that would be a good way to handle it.
Add that agenda item, because you're under no obligation to open the hearing again on this matter.
I'm not sure we would. We've heard it twice.
I don't know that anybody's
I'm not
under pressure.
inclined to open the
Okay.
hearing
So-
again, but I think we have a separate issue.
But add an agenda item to discuss this issue and then make the decision, and up or down, I'm fine with that decision.
I think
I
in
mean,
the
that's-
interest of, I don't think it hurts.
Would you like to
for
make
us-
a motion?
I would like to make a
Well,
motion.
you can't make any motions here.
Yeah.
Oh, no, in the work session.
Before we consider
So
that,
we
is
can-
is the applicant absolutely not willing to reapply as per the city's offer? I just want to clarify that the applicant is not willing to reapply per the city's offer.
And by reapply, you're referring to?
Take the mulligan.
To take the mulligan, to basically have our appeal, renotice it, we'll go through the public hearings again. I would want the opportunity to confer with my client, because again, that's where the breakdown in communication with,
Okay.
and we'll be happy to
That's a
do
part-
that and
Because that
let
could
you
change
know.
everything.
Yeah.
But like I said, I mean, our understanding was whether or not we were going to ask you all to have public hearing, and we said, no, you all have heard it, so.
Do you have time to confer
We will-
before 7?
We will confer
Okay.
and let you know.
Could we,
On a very short timeframe, can we push this item back to the end of the agenda? During the
We could absolutely do that in the organizational and procedural.
Yeah, so
items.
Don, I'm sorry, I
But-
mumbled that, I apologize. I said,
But move it to.
could
I
we
mean,
move it
has
towards
to
the
remain
end to give them
unfinished
time to
business.
talk?
Yeah.
Because you're right, it changes the dynamic of the conversation.
Has to remain an unfinished business.
But we can still, I think we can still move unfinished business to the end.
If we're reorganizing the agenda in our regular session, and we are, doing so in organizational and procedural items, do we have the opportunity to move unfinished business or one case of the unfinished business, because we have two tonight, to the end of our agenda
You
otherwise?
can do that as long as there's no objection from the parties.
We have to get that from.
We could,
Oh, so you don't object, Ms. Julie?
We do not object.
Thank you.
So that if we move all of unfinished business, we need to get one more approval then.
From our ZBA 54.
14-54, yeah.
Okay. No, we'd leave
No, we could leave
split
54
unfinished
and
business.
just move that
We'd leave
case.
54 where it is.
Okay.
Okay. Any other items of concern?
Now can I move to close the work session?
Absolutely.
I'd so move.
Mr. Chair, I just wanted to say one thing. It is about 8 minutes to 7. I don't know if you wanted to consider possibly just referencing well, I don't know if you want to make a decision to possibly delay the regular meeting from beginning, maybe 10 minutes. I don't know if you wanted to make an announcement of such.
I think we should move, well, let's vote on well, no, we can't close this
We
meeting.
can't close this
I
without-
withdraw that motion, I make a new motion. I move that we start the regular meeting at 7:15.
Second.
Okay, any discussion? All in favor of adjourning and starting the regular session at 7:15, signify by saying aye.
Aye.
All opposed? We're adjourned.
Thank you.